Here is something that is not in the headlines. The Attorney General of the Federation, the Chief Law Officer of the Federal Republic of Nigeria, was listed as a defendant in this case. He was supposed to be fighting against the deregistration of these parties. Instead, he filed a notice with the court admitting the plaintiff's case and openly backing the suit. A man named as a defendant openly joining the team trying to destroy the parties he was meant to protect. When the highest law officer in the land switches sides mid-case, whose interest is he serving? And that question matters enormously today because a federal high court in Abuja has just ordered INEC to deregister 5 political parties, including the African Democratic Congress, the platform Atiku Abubakar has staked his entire 2027 presidential bid on, and the Accord Party, the only platform standing between Adeleke and an August governorship election in Osun State. The question this video is going to answer is the one nobody is asking clearly enough. Is this constitutional housekeeping, or is this the APC using the courts to clear the field before voting even begins? Stay with me, because by the time we finish, the answer will be obvious and it will not be comfortable. Before we go any further, if you are new to this channel, welcome. Naija Insight Desk exists for one reason: to give you the kind of analysis that goes beyond the headlines and the noise. Subscribe now because this conversation is about to get deeper. Today is Monday, the 15th of June, 2026. Justice Peter Lifu of the Federal High Court sitting in Abuja delivered a judgment in suit number FHC/ABJ/CS/2637/2026. His order was directed at the Independent National Electoral Commission. Deregister the African Democratic Congress, deregister the Accord Party, deregister the Action Alliance, the Action People's Party, and the Zenith Labour Party. 5 parties, 1 judgment, 1 morning. The plaintiffs were the incorporated trustees of the National Forum of Former Legislators. The defendants, at least on paper, included INEC, the Attorney General of the Federation, and the 5 affected parties themselves. Their argument was legally framed but politically precise. These parties had failed to satisfy the minimum electoral performance threshold prescribed under Section 225A of the 1999 Constitution as amended. That section requires a registered party to win at least 25% of votes in a presidential or governorship election or secure at least 1 elective seat at the federal, state, or local government level. None of the 5 named parties, the plaintiffs argued, had crossed that bar in the last election cycle. Justice Lifu agreed. He dismissed all preliminary objections from the defendants, found that the parties had breached the constitutional threshold, and directed INEC not only to commence deregistration, but to bar these parties from presenting candidates for the 2027 general elections. Now, why today? Why June 2026? The timing is not accidental. The Osun governorship election is scheduled for August 15, 2026. Atiku Abubakar had just literally within days announced Rotimi Amechi as his running mate under the ADC banner. Opposition figures who fled the chaos of the PDP and the Labour Party collapse had found a new rally point in the ADC. The NDC was still building its infrastructure. And the Accord Party was the specific vehicle chosen by a sitting governor, Adeleke, to defend his seat in less than 9 weeks. This is not housekeeping. This is surgery, performed at precisely the most politically devastating moment. Who filed this suit and who really funded it? We'll come back to that. Let us start where lawyers start: the law. Section 225A of the 1999 Constitution, introduced through the 4th alteration, gives INEC the power and arguably the duty to deregister political parties that fail to meet electoral performance thresholds. The provision uses the word shall, not may, not can at its discretion, shall. The plaintiffs anchored their entire case on that word. They argued that INEC had no residual discretion. If a party failed to cross the 25% vote threshold or failed to win any single seat at any level, INEC was constitutionally obligated to remove them. End of argument. and the Attorney General of the Federation, Prince Lateef Fagbemi, SAN, who was listed as the second defendant in this case, filed a notice essentially agreeing. He argued it was his constitutional duty as the custodian of the Constitution to support the plaintiff. He said supporting the deregistration aligned with his mandate to enforce the law and protect democracy. Stop there. The AGF is a defendant. The parties he was ostensibly defending are also defendants, and he chooses to admit the plaintiff's case and back the suit against them. The ADC spokesman described this as an absurdity, and they are not wrong. In any normal adversarial legal proceeding, a defendant who effectively joins the opposing side raises immediate questions about the integrity of the process. Now, what does the Constitution actually say about party deregistration, and has it been done before? Yes, INEC has deregistered parties before, most notably in 2022, when it removed 74 registered parties that failed to win any seat in the 2019 general elections. That action was contested but ultimately upheld. The legal framework for deregistration is real and has precedent. But here is where the institutional analysis gets complicated. Governor Adeleke's team raised a point that cuts to the heart of judicial procedure. The Court of Appeal, in proceedings held on May 22, 2026, had ruled that the delivery of the Federal High Court judgment was still part of the proceedings in an ongoing appeal. In plain English, a higher court had told the lower court to pause, and Justice Lifu proceeded anyway. Adeleke's spokesman was explicit. The judge had been presented with the Court of Appeal's May 22 proceedings as Exhibit MAC-2. It was on the record. The higher court's instruction was before him. He delivered judgment regardless. If that account is accurate, this is not just a controversial ruling. It may be a jurisdictional breach, a lower court proceeding in defiance of a higher one. That is a different category of problem, and that is precisely why the Court of Appeal is scheduled to take up the matter as early as tomorrow. Where does legitimate authority end and overreach begin? Right there. At the moment a Federal High Court judge with the appellate court's instruction before him proceeds to deliver a judgment that could collapse 5 political parties and redraw the 2027 electoral map. That is the line.
Let us now remove the legal language and speak plainly about what this ruling accomplishes politically. Atiku Abubakar declared for the ADC. He had just selected Rotimi Amaichi, a former Rivers State governor and APC stalwart, who crossed to the opposition as his running mate. That ticket was designed to project national spread, a Fulani Muslim from the north paired with a Rivers Christian from the south. It was the kind of structural coalition that worried the APC establishment. This ruling, if it stands, ends that ticket before it begins. Adeleke's situation is even more immediate. The Osun governorship election is August 15, 2026. Not 2027, August, 9 weeks away. He had recently declared for Accord after leaving the PDP. His campaign flag-off was scheduled for tomorrow. He now faces the prospect of fighting for the legal existence of his own party while simultaneously running for his political life. ADC's spokesman went further than most were prepared to go publicly. He named a specific individual allegedly behind the suit, someone described as working in the office of the Chief of Staff to the President, identified as a former House of Representatives member from the Southeast. He noted that this person was not hiding. Then, he raised the AGF anomaly, a defendant who turned plaintiff, and asked the obvious question: in what legal logic is that permissible? The APC has denied any involvement, but let us map the incentive structure. The ADC was the most dangerous opposition vehicle in the country at this moment. It had inherited the momentum of the Obi Kwankwaso movement's organizational infrastructure before those two departed for the NDC. It had David Mark returning to stabilize it. It had Atiku with a newly announced running mate. It had opposition governors and legislators rallying under it. Every day that passed made it harder to stop. Now consider who is conspicuously silent: the PDP, the NNPP, other opposition parties who could have spoken out in solidarity with multi-party competition have issued no joint statement. Their silence tells you something. They see the ADC's elimination as potentially beneficial to their own positioning. And what of the NDC?
Peter Obi, who was with the ADC until May, reacted on X, calling the ruling an attack on institutional integrity and demanding it be reversed. But Obi is not in the ADC. He is safe in the NDC. This ruling does not touch him directly. Which brings us to the second-order consequence that is being underreported. This ruling creates a massive pressure wave pushing opposition figures toward either the PDP or the NDC. If the ADC is eliminated, where do Atiku's delegates go? Where do Adeleke's structures collapse to? Does the PDP recover relevance it has been steadily losing? Does the NDC, barely months old, absorb a flood of defectors it is not yet structurally prepared to manage? The ruling does not end the opposition. It fractures it further. Here is a number that should stop you. The 5 parties being deregistered collectively fielded candidates across 36 states in 2023. If their candidates, their agents, their polling unit representatives are stripped of legal standing before 2027, INEC loses a layer of opposition observation infrastructure at exactly the moment a contested election is most likely. That is not a side effect, that is a structural consequence. Now, if what you just heard challenges what you thought you knew, drop it in the comments. I want to hear your read on this before we get to the part that reframes everything. We promised to come back to who really filed this suit. Here it is. The suit was filed on April 23, 2026 by the Incorporated Trustees of the National Forum of Former Legislators. They described themselves as a civic body acting in the public interest. They leaned on the word shall in Section 225A. They brought in the AGF as a defendant who then openly endorsed their position. A former House of Representatives member allegedly connected to the President's Chief of Staff is named by the ADC as the driving force. In Nigerian political architecture, former legislators forming civic bodies to file strategic constitutional suits is a familiar mechanism. It provides legal cover, creates institutional distance, and allows elected officials and their allies to pursue political objectives through the judiciary without direct fingerprints. Whether or not the allegation is true, the structure of the suit, the timing, the AGF's switch, the plaintiff's profile, the absence of any prior civic campaigning by this group on similar issues invites the question the ADC is now putting publicly. Now, let us zoom out. What does this ruling mean for Nigeria's democratic trajectory? First, federal-state power dynamics. Adeleke is a sitting state governor. His party is being deregistered by a federal court in a suit backed by the Federal Attorney General 8 weeks before a state election. That's the federal government's legal apparatus casting a shadow over a state-level democratic contest. That is the federalism as serious. Second, ordinary Nigerians. The people furthest from power care about elections because elections are the only moment at which their preferences carry legal weight. If the platform a governor has chosen to defend a mandate given to him by us own voters is eliminated before they can vote again, those voters lose the right to render a verdict. That is not an abstraction. That is the democratic contact being severed. Third, investment climate. Peter Obi made this point on X, citing the removal of former Chief Justice Onogain as a precedent. Investors do not flee obvious risks, they price them in. What they cannot price is institutional unpredictability, a court that delivers judgment after a higher court orders it to pause, an attorney general who switches from defendant to supporter mid-case, political parties dissolved 8 weeks before an election. That unpredictability is a risk premium that every foreign investor watching Nigeria is now calculating. The 5 parties being targeted were not micro-parties. Zenith Labour Party contested in Ondo. Accord held a governorship inquirer until 2011. ADC was a platform for Peter Obi himself as recently as late 2025. These are not phantom parties. They are parties that lost. And in a democracy, losing an election is not a constitutional crime. Nigeria's 2023 election was already contested before ECOWAS and the African Union as a benchmark for democratic credibility on the continent. Both bodies acknowledged serious procedural concerns while declining to invalidate the result. What they communicated privately and what diaspora communities in the UK, the US, Canada and South Africa have not forgotten is that the integrity of 2027 will be judged against the repairs made between now and then. this ruling does not look like a repair. When opposition platforms are dissolved through judicial action backed by the government's own chief law officer, the language available to Nigeria's foreign partners becomes limited. They cannot formally declare the process compromised. That's an act of diplomatic aggression. What they can do, and historically have done, is quietly reduce financial cooperation, revise travel advisories, and let the multilateral lending community factor political risk into conditionality. For Nigerians in the diaspora, particularly those who mobilized around the 2023 Peter Obi campaign, this ruling confirms a fear that was always present, that the system has institutional circuit breakers that activate when opposition momentum becomes genuinely threatening. The question for 2027 is whether those circuit breakers can withstand appellate scrutiny, and that question goes directly to Abuja's Court of Appeal.
Let me stillman the strongest case for this ruling before I challenge it. Section 225A is real. It was introduced as a reform designed to rationalize Nigeria's bloated party ecosystem, which at its peak included over 90 registered parties, most of them shells with no members, no structures, and no democratic function. The argument is legitimate. A party that fails to win a single seat at any level in any election is not a political party. It is a brand name. Forcing INEC to recognize and manage these entities wastes public resources and dilutes democratic credibility. Furthermore, the plaintiffs correctly cite the word shall. Courts are generally reluctant to read discretion into mandatory constitutional language. If the Constitution says parties that fail to meet the threshold shall be deregistered, there is a textual argument for compulsory deregistration. That is the strongest version of the case. I give it full weight. Now here is where it fails on impact, not on principle. 1. Timing. A constitutional mechanism designed to clean up the party system should not be activated in the weeks before a major election. There is a reason election management bodies worldwide observed pre-election moratoriums on structural changes. The legitimate goal of rationalizing parties does not require doing it in June 2026, with elections in August 2026 and 2027. The Constitution does not set the clock. Someone made the decision to move now. 2. The Court of Appeal dimension. If Adeleke's claim is accurate, that a higher court had ordered a stay of proceedings and that the record was before Justice Lifu, then the legality of this judgment is genuinely in question, regardless of the constitutional merits. A correct rule applied through an incorrect procedure is still procedurally defective. 3. The most common misconception circulating on social media right now is that this ruling means Atiku, Adeleke, and Peter Obi cannot run in 2027. That is not accurate. It means the parties they are currently using may not be able to present them as candidates. Atiku can defect, Adeleke can defect. Obi is already in a different party entirely. The NDC is not affected by this ruling. The candidates survive. The question is whether they can reconstruct viable platforms fast enough to matter. What happens next? The Court of Appeal sits tomorrow. If it rules that Justice Lifu's judgment was delivered in defiance of its May 22nd order, this entire ruling could be suspended or vacated within 24 hours. What looked like a fatal blow this morning may be a procedural nullity by Wednesday. Watch the Court of Appeal, not the social media commentary. 3 most likely next moves. 1. Appeals and injunctions. The ADC has already declared it will challenge the ruling through every lawful avenue. Adeleke's legal team is moving tonight. The Court of Appeal hearing tomorrow is the immediate battleground. If they obtain a stay of the Federal High Court's order, both parties survive in legal limbo but can continue operating, which critically allows Adeleke to contest the August 15th election. 2. Opposition realignment. Regardless of the appeal outcome, this ruling has accelerated what was already happening, the migration of viable opposition structures. Expect movement toward the NDC and the PDP in the coming weeks. The question is not whether this happens, but at what speed. A disorderly rush could fracture the opposition further. A coordinated transition could consolidate it around 2 or 3 platforms rather than 5 or 6 fragmented ones. 3. APC credibility cost.
The ruling may eliminate ADC candidates from the ballot, but it will also energize the opposition narrative going into 2027. Every defection triggered by this ruling becomes a story. Every court date becomes a referendum on democratic integrity. The APC may have won this particular legal battle at the cost of a wider political narrative it cannot easily control. What signals should you watch for? Watch the Court of Appeal ruling tomorrow, specifically whether it addresses the May 22nd stay of proceedings question. Watch INEC's response. The Commission has been given an order. If it complies immediately, the situation hardens. If it moves slowly, waiting for the appellate outcome, it is signaling that it considers the ruling contestable. Watch Atiku. His response will tell you whether the ADC hierarchy believes the appeal can succeed or whether they are already preparing defection strategy. Watch the Osun election. August 15th is a hard deadline. If Accord survives the appeal, it is the opposition's most immediate electoral test under this ruling. If Accord is eliminated before that date and Adeleke is forced to contest under a different platform or withdraw, that's a data point about what this ruling means in practice. I opened this video with one question. Is this constitutional housekeeping or political surgery? Here is my answer. The legal basis for deregistering underperforming parties is real. Section 225A is a legitimate provision, and the argument for rationalizing Nigeria's party system has genuine merit. On that principle alone, the plaintiffs are not wrong. But the timing, the AGF's role, the alleged defiance of a court of appeal order, and the identities of those who stand to benefit politically, taken together, do not resemble housekeeping. They resemble a deliberate, legally dressed strategy to remove the most dangerous opposition vehicle from the 2027 battlefield at the precise moment it was becoming viable. That does not mean the ruling will stand. The Court of Appeal could vacate it tomorrow. The Supreme Court could weigh in before the Osun election. The opposition could consolidate around the NDC or the PDP and emerge stronger than it was before. What it means is this. Nigeria's democratic architecture is being tested at its joints, and the joints are showing strain. The question for every Nigerian watching this, whether you support Tinubu, whether you support Atiku, whether you are in Osun or Abuja or London or Houston, is not who wins the next court date. It is whether the institutions that are supposed to arbitrate between power and the people can still be trusted to do so. That's the thread I'm leaving open, because we will revisit it. And if this ruling is upheld all the way to 2027, the next video in this series will be the most important one we've made. If this analysis gave you clarity, not agreement, clarity, share it with one person who needs to understand what is actually happening. Like, subscribe, and I'll see you in the next one.